may have been told that you have a preliminary hearing or a preliminary hearing is coming up, and you may have questions of what that is. A preliminary hearing is a stage in the criminal case only on felonies where the district attorney has to prove and show that there's some evidence to indicate that you've committed the crimes charged. The language that the court will use is a reasonable suspicion that the crime charge has been committed. The preliminary hearing occurs after the arraignment. In Ventura County, preliminary hearing occurs after what they call an early disposition conference. If the early disposition conference doesn't settle the case and there's issues to be contested, a lawyer will set the case for what they call a preliminary hearing, where witnesses have to be called by the prosecutor to establish that there's a reasonable suspicion that the crime was committed. In Santa Barbara County, there'll be an arraignment and then a preliminary hearing settlement conference, and then the preliminary hearing setting. Before you decide to go to preliminary hearing, you have to decide whether or not you want to make a deal with the prosecutor. If you don't want to make a deal and if you want to contest the case, then it's one of the most important stages in the case. It's your chance for your lawyer to start establishing the defense that you want to use at trial. What I always recommend is that I'm not usually going to preliminary hearing unless I'm thinking about going to trial. You may have more questions about preliminary hearings or other issues about criminal law, and if you do, please give us a call. We'd be happy to answer them.